Hey folks, this is Dennis Boren. I'm a criminal defense attorney and a former felony prosecutor. And today I wanted to talk to you about kind of the process between arrest and prosecution. Now, hopefully you never need to know this information for yourself, but it could be helpful if someone you know or a friend or family or loved one gets in some trouble, so you kind of have a little bit of an idea what's going on. First of all, the police can't take you into custody without a warrant. There's some exceptions to that though. Let me just talk about warrant arrest. That's when a case has been taken to a prosecutor and the prosecutor has accepted the charges, which means they filed a criminal complaint. And somebody with knowledge, it's called probable cause. Usually it's a police officer saying, yeah, this person, he has reason to believe he did it, and he did whatever the crime was, and he has personal knowledge that to be true and correct. That way a prosecutor just can't go up and file charges against somebody willy-nilly. There's somebody with knowledge. Now that's a warrant arrest. Now, and I'm going to talk to you about warrantless arrest in just a second, but when there's a warrant, very often they don't serve that warrant. That just means they don't go out looking for the accused actively. Now they do sometimes. They'll go look every place they know to look. Family, mom, dad, uncle, brother, sister, girlfriend, whatever place they know you might be, or work. That happens very often. Now, there also is an arrest based on warrant, very often based on a traffic stop. When you get stopped or you see somebody stopped, the officer comes up and he asks for your driver's license, and then he goes back to his vehicle and you see him on the radio. Well, he's calling in the dispatcher to look up on the computer system to see whether or not there is a warrant for this person. And they can arrest somebody even if you just had a tail light out and they run you or the person and they find there's a warrant. They can arrest that person because of the warrant. Now, warrantless arrest. There are some exceptions to this, but generally speaking, if an officer witnesses this thing or transaction or crime occurring, they don't have to wait to arrest. They don't have to run to court and get a prosecutor first to file a complaint and the judge will issue what's called a bench warrant. So they can arrest somebody on the spot. Now, a lot of people will say, particularly if that happens, that I've been charged with burglary of habitation because the officer saw the person coming out of the place they didn't have permission to be in. And somebody called and said, hey, I saw somebody go in the structure, and they go in and either find them or see them coming out. They can arrest that person. And they'll say the police have charged me with burglary of a habitation. Well, technically, that's not right. You're just being arrested really on the suspicion of burglary of a habitation. But you still go to jail. Now here's where it gets where you really need to get a lawyer involved. Whether it's me or somebody else at this stage, because when you're arrested like that, you're going to be what's called magistrated, usually within 24 hours. That means usually a low-level judge, like in Texas, a justice of the peace, that it's going to just tell you what you've been arrested for. They can't really arraign you because you're not been charged with anything. So it's really not an arraignment. That's after you're charged and you're told what you're charged with. They're going to set a bond at that point, typically. And typically the bond is going to be ridiculous. Not always, but they're just going to just make up the bond based on whatever Ouija board or whatever, roll of the dice they're using. Or they're going to look at a recommendation made by the prosecutor's office, which is often ridiculously high. So if you can get an attorney involved at that stage, I just had one the other day where we actually had to file a writ of habeas corpus or an application for a writ so I can get in front of a district judge. It was a low-level felony, state jail felony, and the bond was $50,000. What ought to have been like $5 at the most. So I got with the prosecutor and I filed this writ, application for the writ, and we got the bond reduced dramatically. So just wanted you to know kind of how it worked, have a little bit of knowledge. Hope this was helpful. And like I say all the time is if you have an interaction with a police officer, please just turn on your video or at least your audio app on your phone and document it. It will save you a lot of grief. Hope this was helpful.